Plaintiffs contend that in applying the brakes with such force as to cause the vehicle to stop suddenly, the defendant was negligent. The defendant, on the other hand, denies that she was negligent in stopping the vehicle, denies that she had anything to do with the accident, and denies any culpability whatsoever. The plaintiff states that the cause of the accident was not her, that her injuries were not from her own misconduct. Defendant also contends that the plaintiff's injuries were not of the nature and extent contended by the plaintiffs. Remember, members of the jury, that it is your recollection of the evidence which is to control here. Noting that I have said nothing that counsel in their opening statements or in their summations have said regarding the facts is to control. On the other hand, and with equal underscored emphasis, I charge you that you are bound to accept the law of this case as it is given to you by this court. You must know that the rules of law applicable to this case are because it will be your duty to apply these precepts of law to the facts as you have heard them, that whether or not you agree with the law as charged by the court, you are nevertheless bound by it. You render your verdict based upon the facts as you decide them and under the law as charged by this court. Throughout this trial, the attorneys made motions or objections which I ruled upon. Neither these motions nor my disposition of them is of any concern to you, and you should not think about them while deliberating in the jury room. Similarly, you should not consider the argumentation of counsel, their preliminary opening statements, or their summations as evidence, for they are not evidence. Any personal colloquy or disputation between counsel or between any counsel and the court are likewise not to be embraced as part of the evidence in this case. You must consider only the testimony of the witnesses and the exhibits introduced during this trial in determining your verdict. Every lawyer must plead the cause of his client to the best of his ability. This is his duty as an attorney and as an advocate, and personalities must not color your deliberations. Only the evidence and the stipulations are significant. As I have already told you, this is a negligence action. In such an action, the plaintiffs have what we call the burden of proof and cannot recover a verdict on either cause of action unless they establish three things by a fair preponderance of the credible evidence. First, the plaintiffs must establish that the defendant was negligent so as to cause the plaintiff Mary Ryan's injuries. Second, the plaintiff must also establish that the plaintiff Mary Ryan herself was not guilty of any negligence whatsoever, contributing in any degree to the occurrence of the accident that allegedly caused her injuries. And third, that the plaintiffs must establish the nature and extent of the plaintiff Mary Ryan's injuries. Remember, the plaintiffs must establish these elements of their case by a fair preponderance of the credible evidence. Now, what do we mean by a fair preponderance of the credible evidence? By a fair preponderance of the credible evidence, we mean the weightier evidence, that which bears down upon the scales in favor of the plaintiff. It is the measure of evidence which generates conviction in your mind. Until you are satisfied as responsible persons that a fact exists, you cannot say that the burden of proof has been met. If the evidence is so evenly balanced that you cannot state whether the alleged fact is so or not, that the burden of proof has not been met. But if you become convinced that what is claimed to be a fact is actually a fact from the evidence that you have heard or from reasonable inferences from that evidence, then the burden of proof is met. Other things being equal, the greater number of witnesses testifying in the same way about a transaction in question would ordinarily carry the greater weight. But whether the things are equal depends upon the degree of weight which you, the jury, give to the testimony of the several witnesses. Pretty snappy.